Hello, I am Amy Klocke with the Goosmann Law Firm, and I'm here today to talk about possible issues to be mediated in a divorce and/or custody case. And I have Jamie here with me today who may be jumping in to ask some questions. And we'll go ahead and get started here after we read the disclaimer, of course. The Goosmann Law Firm engages in the practice of law and provides legal advice and opinions. The information contained in this presentation is not and should not be construed to constitute legal advice for you or your company. You should engage counsel to analyze your situation. Now that we got that part out of the way, we'll go ahead and get started. Basically, I came up with this webinar. I found a checklist in the Iowa State Bar Association manual that outlines a lot of the areas that people have questions about and just streamline the process a little bit more, because you can't possibly think of every issue that may come up when you're negotiating your divorce or child custody case. And the purpose of resolving or a court decree ending the marriage or solving the child custody issues is to last until the child is 18 years of age. Obviously, that's very difficult to do because circumstances can change, but that is the goal when setting out to resolve these issues, is to do it once and to do it right the first time. So this is a checklist that I use with my clients to go over all of the areas and get the wheels turning so we fully discuss all the issues that they may want to negotiate or need to negotiate in resolving their case. Okay, parenting agreement. The parenting agreement will outline the visitation or the custody arrangement between the parents. Now, a lot of times what I try to put in the agreement, other attorneys also try to put, is that the agreement shall be as the parents agree. But sometimes parents cannot agree, or they can agree for a while and then they stop agreeing. And that can go back and forth many times. So what the courts like to do is say, if the parties cannot agree, here's what the schedule will be. And the areas that the court wants the parties to address would be the school year. What is the parenting schedule during the school year? And what about school breaks? Especially if the parties live in different towns, you may want to have more visitation during the school breaks. Others just want to keep the visitation the same schedule regardless if the children are in school or not. Holidays. Clearly you want to work out some arrangement to divide up the holidays. A lot of times parents will rotate the holidays depending on even years and odd years. So for example, you may get Christmas Day in odd-numbered years, Christmas Eve for even-numbered years. Other times, families have traditions set out where they may always celebrate on Christmas Eve, and the other side may always celebrate on Christmas Day, so they keep it the same every year. And the parenting agreement is supposed to be what works for the children and the parents. So it really can be whatever you want. A lot of times clients will say, well, what should I have for my parenting time or my parenting agreement? And it really is an individual process. Obviously, I can make recommendations based on the situation, how easily the parents can get along or not, where they live. For example, if they live on the same street, which I've had before, it makes it really easy to split holidays. But those things just need to be addressed so everybody knows basically the rules of the parenting time. The parent's birthday, that can be addressed. The child's birthday, who gets to spend their birthday with them, or they get to split the birthday. Vacations with the children. A lot of times there's provisions saying that each parent can go on a 2-week vacation or have the children for 2 weeks for a vacation in the summer, but they must give a certain amount of notice. Time with extended family. Sometimes that'll come up in right of refusal paragraphs where if the parent is going to be away for so many hours, then they must offer that time to the other parent. Clearly, that would limit time with extended family. So those are things to think about when making those proposals or agreeing to those proposals in the parenting plan. And schedule changes. So work schedules, for example, how are you going to handle different work schedules or if the work schedule changes? And obviously, it's best to try to anticipate and think ahead, so this only has to be done once. But the ideal is that the parents can agree and work around any changes and work with each other to ensure parenting time for both parents.
Amy, what if one parent has holidays and has parenting time and they just don't use it, or they skip holidays and they don't spend the time that's outlined in the parenting agreement?
Good question, Jamie. A lot of times it'll say the parents, if they're 15 minutes late, they forfeit the visitation. Obviously, you can't make a parent want to have visitation time with the child, but depending on if it's a joint physical care situation, you could potentially go back into court for a modification to ask to have that change to primary care. Because with the parenting time, we're assuming that the parent is paying for that child's care during that time. So if you have a 50-50 situation, child support is figured based on each parent having the child for half of the time. If that parent does not exercise visitation, then the other parent is paying for the food, clothing, housing, and the child support needs to be refigured to a primary care situation. Okay, communication, telephone access between children and parents, social media contact between children and parents. Obviously, the courts want both parents to have a very significant, strong relationship with the children. So most times the orders will say that there's liberal access to phone, social media, contact between the parents and the children. Transportation, this can be an issue at times. A lot of times the judges will say whoever's parenting time is starting is responsible for picking up the child. Sometimes the parents will just agree to another arrangement that works for them, maybe meeting halfway, picking the children up at school. In real volatile situations, sometimes parents will do 1 week on, 1 week off. This is not recommended for young children, but maybe older children, and the drop-off pickup happens at school. So every Friday at 3 o'clock or 3:30, the parent who's starting their time to pick the children up at school. It just kind of depends on the situation and what works for the parents. And then legal custody. We have to decide what the legal custody arrangement will be. It is almost always joint legal custody, which means the parents have equal say in education, medical care, any kind of legal issues involving the child records and access and things like that. That's almost always joint legal. Okay, oops, decision making. Let's see. How will joint decisions be made? Who wants to be included in decision making of the following issues? So normally this is just joint legal and the parents have equal say, but it's important to think about education. If one parent wants the child to go to a private school and the other wants the child to go to a certain public school, that needs to be decided. Healthcare, do both parties believe in immunization? Sometimes that's an issue. Child care, the parties will oftentimes agree if they have a young child that they will utilize the same daycare provider rather than having their own and alternating week by week, for example. Children's activities, this can come up where the parties will agree to split costs of children's activities, such as athletic shoes or equipment, things like that that are just additional expenses as the children get older. Religion, sometimes there are fights about what religious preference the child should have, and that needs to be addressed. Motor vehicles, driver's license. A lot of times, if it's an issue, the parents will put that the parent must have proper insurance and must have a licensed driver pick up the child, or if there can be anyone else to pick up the child. Those areas can be negotiated and addressed as well. But basically, it's important to know how the joint decisions will be made, how disagreements will be handled. And an example for that would be a mediation clause, for example, where before filing a modification in court, the parties must make a good faith attempt at mediation to try and resolve these issues. The hard part for the court is both parents have equal say, and if both parents have opposite beliefs, it's extremely hard to make one decision for the children. And the courts are oftentimes tasked with doing that if the parties cannot work out the disagreement. Now, the parenting agreement should also address communication, information sharing. It makes it a lot easier if the parents are willing to communicate about issues with the child's school, or if they're sick, if they're needing to go to the doctor, religious training, moving beyond the current geographical area. A lot of times parents will put in the agreement that if a party moves so many miles outside of a certain area, they must give notice, 60 days notice to that parent. Any method to improve communication between the parents will help make this a smoother transition for the child and make the agreement more likely to last for the duration of the child's, I guess, while they're a minor. Okay, financial support. Obviously, child support needs to be figured using the child support guidelines, which looks at the parent's income, the number of children, and other factors to determine the amount. If there's any spousal support, any post-secondary education costs. In Iowa, a parent can be ordered to pay a third of a child's tuition costs for a state school in Iowa if the court deems it is necessary. A lot of times, if there's young children, the parents will reserve the right to go back to court over that issue when the children get older, because they don't know, number one, if the child's going to go to college, number two, if it's going to be a state school in Iowa. So a lot of times that will be reserved. Responsibilities for children's expenses. Sometimes parents want to address who's going to buy a car for the child. I don't always recommend getting that micromanaged or detailed, but it really is an individual decision for parents. Sometimes they'll agree to split the cost of a cell phone, kind of whatever they want to agree to that works best for them. The court will obviously order some kind of medical insurance to be provided for the children. And then, of course, the uncovered costs need to be split between the parents. Usually the parent providing insurance will pay the first deductible up to $250, and then they split the uncovered costs at a certain percentage. Sometimes it's not always 50-50. It may follow the child support guideline percentage of income. Financial support for the activities that I talked about before, clothing. Sometimes if it's a joint custody situation, joint physical care situation, each parent will provide their own clothing for the children. And any other areas that the parents feel are necessary to spell out in the agreement the exact financial support expectation, maybe for private school, or if they want to agree to some other additional daycare costs or an after-school program costs, they can agree to that in this area of the parenting plan.
Amy, how is it established financial support, such as like child support or child custody, when you're not married? Does that make a difference as far as the support that you get?
No, it's the exact same, Jamie. The court, there's a formula, and the court will put in both parents' income, and we'll figure like health insurance, number of children, if it's joint physical care or primary, and the formula will come up with a number of what the amount of child support is. And it doesn't matter if the parents are married or not, it's strictly income-based. Good question. The other areas that the parenting plan needs to address, I talked about a little bit before, is health insurance. Sometimes life insurance. Parents will agree that they will hold a life insurance policy for a certain amount. So if the parent does pass away, that child would have some kind of support. So that can be done. Family home needs to be determined if the home will be sold and the proceeds split, or if one party will keep the family home. A lot of times, as part of the agreement or court order, the spouse that is not staying in the family home must sign a quitclaim deed relinquishing legal right to the home, and the party keeping the home must refinance the home to get it out of that other party's name. because if they do not, there could be financial issues for that other party that they certainly would want to avoid, like a bankruptcy. Other real estate needs to be determined where it goes, if it's sold, what happens to it. Household goods, personal property needs to be divided. I always recommend that the parties work this out between themselves. It's not very efficient to use an attorney to argue over personal property. So it's best if the parties can just agree to the personal property items. And of course, then vehicles, which can be similar to homes, where the vehicle's in both names. So one of the names needs to be taken off, or the vehicle needs to be refinanced to get that out of the other party's name so they're not financially liable for that vehicle. And then the list goes on and on. We have business ownership interests that need to be addressed. Obviously, you don't want to run a business with your ex-spouse necessarily. Stocks, bonds, bank accounts, any kind of debts, other assets, everything needs to be divided up and thought about, such as retirement accounts. All of those need to be determined by the parties or the court as to how they will be divided and who will take what assets and what debts. And the court will look at an equitable distribution. So basically, the assets and liabilities are figured, so it's essentially a 50-50 for the parties unless there's some kind of different circumstances that the court can consider. Talk just a little bit about retirement, pension plans, IRA accounts. Those accounts need to be divided or determine who will keep those accounts in exchange perhaps for some other asset. And then with the children, there's tax issues. So you want to talk to your attorney about who gets the child tax dependency deduction. Do you alternate every year? If you have, let's say, 3 children, do you each claim one child and rotate the third child? That all needs to be divided. Under the IRS rules, a parent would have to execute a form to say that they're not claiming the child that particular year, so the other parent can claim them if that's what the agreement says. If both parents claim the same child, that's going to trigger a red flag for the IRS. So you definitely want to avoid that and just agree how the tax issues will be handled. The refund, if you're going through the divorce, who's going to get the refund? Will it be split? If you owe money in and you file jointly and you're going through divorce, who's going to pay that balance? And then, of course, any capital gain taxes that could come up as well. And then finally, maybe attorney fees will be up for discussion and negotiation. If one of the parties does not have the ability to pay for attorney fees, they will ask the other party to pay a certain amount, or they will ask the court to order a certain amount of attorney fees. And then we already talked about future mediation clause from parties like this, because it's usually cheaper to go through mediation and resolve the issue rather than file and go back into court to fight over specific issues. And while the divorce or child custody case is pending, temporary orders can be sought and stipulations can be had with the temporary regarding housing, who will remain in the house, who will pay for the house, what the temporary parenting schedule will be, temporary child support, temporary alimony, and managing any kind of assets and debts. And then obviously if there's a temporary order, the final order will overrule that temporary order. And a lot of times it's assumed that the temporary order will become the final order, but that's not always the case. Sometimes it is, but it just depends on the facts and circumstances that the judge sees during the trial. And I think that's all we have for the areas that I wanted to go over with everyone. Just some things to think about if you are negotiating a divorce or child custody case, or you're meeting with an attorney. This is kind of a good checklist to bring so you make sure and fully discuss all these issues with your attorney so they are addressed and your case is done right the first time. Thank you very much. Okay. I felt like I was just rambling, but
no,
whatever.
Totally fine.
Yeah, that's good.
All right.
Good. Okay. Stop sharing. Yay! It only took 3 times. End event. End event.